Greetings, folks. Welcome to the Law of Fojo podcast. I am your host, Robert Fojo. I am a practicing lawyer, but somewhat of a recovering lawyer turned legal and political commentator. The way politics and the law work together is one of my passions. This show is more like a classroom. We advance conservatism for you, a new generation, and we teach you that liberalism is the disease, a lot worse than coronavirus, and conservatism is the cure. I am thrilled to be here with you today. Class is in session. I'm doing something a little bit different today. I've gotten a lot of inquiries concerning how to sue a state or local official for a violation of civil rights or constitutional rights. And I wanted to just take the time to run through what exactly that is, how to do it, what are the components of it, some things you need to think about, and then how to go about doing it. This is a broad strokes sort of discussion, and I'm going to cover things in a very general way. Obviously, there are going to be nuances to a lot of these issues, and there are some things that are going to vary from situation to situation depending on the facts. This is obviously not legal advice of any kind. I'm just providing you with my knowledge, and then if you choose to use this for your own interests, obviously you should consult an attorney and get the appropriate legal advice. So let's start with what this is called. This mechanism for suing a state or local official um, is known as a Section 1983 action. A um, it's a lawsuit, and action is another word for a lawsuit. And the way it works is this is a lawsuit brought under a specific federal statute. It's known as Section 1983 of Title 42 of the United States Code. What this mechanism allows you to do is it provides an individual with the right to sue a state government employee or someone else acting under, these are the keywords, under color of state law. Now, this is essentially a legal claim that alleges that a state or local official has violated your civil rights under the Constitution. And these actions can be brought in either state or federal court. Now, it's important to make this distinction. Section 1983, that statute does not it doesn't provide civil rights. It does not create a civil right. Okay, you're not suing for a violation of a Section 1983 right. It's a means to enforce civil rights that exist elsewhere. And if you recall, if you know where I stand on this, and if you recall how I've explained this in the past, we are born with rights. Those rights were given to us by God or nature, or however you want to classify it. And then we give up some of those rights to government in exchange for government to protect our rights. So these rights exist elsewhere. And 1983 is merely a procedural mechanism to enforce those rights. Section 1983 provides federal courts with jurisdiction to hear civil rights cases. It's a procedural mechanism for you to bring this claim in federal court and allege that a state official or a local official has violated your constitutional rights or federal statutory rights. Now, this is an extension of what I was just explaining. A public official is not liable under Section 1983. All right. Rather, the statute creates liability for violating another federal right, whether it's a constitutional right or a federal statutory right. If you were to prevail under this statute, the official that you are suing would not be held liable under the statute itself. The official is going to be found to have violated some other right, and you're just using Section 1983 as a procedural mechanism to enforce that right or those rights. Oops, skipped ahead here. Now, what kinds of damages can you obtain in a Section 1983 action? There are two types, or rather, what kind of relief can you obtain in a Section 1983 action? There are two types. One is monetary damages, all right, and the other type is what's known as injunctive relief. Injunctive relief or an injunction is an order from the court that tells somebody to stop doing something or that orders somebody to do something. If you recall from my past discussions on the lawsuits I've handled challenging mask mandates, vaccine mandates, in those cases, we are usually requesting injunctive relief, which is an order from the court that tells a municipality or a school district to stop enforcing a mask mandate. That is known as an injunction, injunctive relief. Um, and that's one of the types of relief you can get in a Section 1983 lawsuit. The other type is monetary damages, which is what you have come to know as money damages in any case. Now, civil rights um, refers to rights that are protected by the Constitution or federal law. Um, the types of rights that are protected um, are usually rights that are um, enshrined in the Fourth Amendment. For example, an illegal search and seizure or an unlawful arrest, or, for example, if you're an inmate and you receive inadequate medical care for an injury you sustained either while in prison or before you arrive there. Police misconduct, the use of excessive force is also conduct that you can challenge under Section 1983, and you're protected from all of these types of conduct, either under the Constitution or some other federal statute. Now, Section 1983 cannot vindicate rights under state law. We have, in addition to our federal rights, we also have rights under state law, but Section 1983 is not the mechanism that you use for enforcing state rights. It's purely for the violation or vindicating the violation of federal rights. A little bit of history on this statute. It was originally intended to protect slaves who were freed in the Civil War. What happened at the time, Southern states passed laws that were harassing and intimidating African Americans, and law enforcement officers were assaulting them, and so on and so forth. So, what happened was the Civil Rights Act of 1871 was passed, and that law allowed victims, such as former slaves, to file lawsuits in federal court and recover money damages. These victims were allowed to file in federal court because if they filed in state court, the prevailing sentiment at the time was that they would face a lot of bias in state court. So they were allowed to pursue these claims in federal court. Usually, federal courts are better forums for avoiding that kind of bias. Um, when I was practicing, at a large firm, we always wanted to be in federal court. If we represented a large company and that company was sued in state court, you generally wanted to get that case out of state court and into federal court because federal court was usually a much stricter process. The judges are usually better in federal court, and you could avoid the biases that exist in state court. So this law allowed victims of these types of this type of conduct to file Section 1983 claims in federal court and recover money damages for the violation of their civil rights. Now, remember I mentioned you can file these in state or federal court. You can file a 1983 claim in state court, but since you're alleging, and this is beyond the scope of this discussion, since you're alleging a violation of a federal right or a federal law or a federal constitutional right, the defendant can always remove it to federal court. So you may end up in federal court anyway. And most plaintiffs usually file in federal court either way, because again, it's a better forum. If you can get into federal court, In many instances, you should, because the judges are better, and it's just a better forum overall. So, what does under color of state law mean? That's the key phrase here. Basically, it means someone who acts as if they have the authority of the state. Okay. An example of this is a police officer or a correctional officer who, while working on the job, acts under color of state law. They act with the authority of their position. State officials can act under color of state law, by the way, and then break the law. That's the whole point of this statute. It's an official who is using his or her official position to break the law or to violate your rights. An example is a state official who violates, for example, an official policy or a legal requirement, but maintains the appearance of state action. This was all too prevalent the last couple of years with all of these COVID restrictions. I would argue that a school board official or a state agency official that issued a mask mandate or a vaccine mandate, I would argue that that individual can be sued under Section 1983 because they are using their office and their official position to violate your rights. Um, I would argue that a mask mandate violates many different constitutional rights. A lot of judges in many of the cases that address this issue would disagree with me, but that is an example of a situation where a public official is using his or her position to violate your rights. This statute is a mechanism to vindicate the violation of your rights and to sue that official. So long as the official has the appearance of being a state actor, he or she can be sued under Section 1983. The point is they need to have the appearance of using their official position. So it's cloaked with authority. It's under color of state law, because they're using it essentially to vindicate their action, when in reality it's a violation of some right that you have. So long as they're acting with the appearance of authority, you can sue them under Section 1983. Appearance of authority can take many forms. For example, it can be as simple as a police officer in uniform or showing a badge. It could be someone claiming to be an officer. It could be someone behaving like a public official. So a school board member taking action at a school board meeting or in some other situation. A superintendent taking action purportedly as a superintendent or based on the authority that that individual claims to have. So it can take many different forms. Another example: police officers who use excessive force when arresting someone. So obviously that is an authoritative action. You're arresting someone, but they go a little too far and push the envelope. So, for example, they may have subdued the suspect. That person's face down on the ground, and they taser that person at that point. That is considered excessive force. That is a violation of someone's constitutional rights under Section 1983. I've handled cases like this before, and this is a very common situation, actually, for the use of a Section 1983 claim. Another example: a municipal official who excludes a civilian from a municipal office or building like City Hall. That is also considered a violation of one's constitutional rights, and Section 1983 can be used to vindicate that right. Police officers who raid and search your home without a warrant. That's a classic search and seizure violation. Section 1983 can be used to challenge that action and sue those officers. Police officers who arrest someone without an illegal basis and hold them overnight without charging them. That is also considered a violation of your constitutional rights, and this statute can be used to challenge that conduct and vindicate those rights. Or a correctional officer who beats an inmate and breaks his leg. That's an excessive force situation again, but it occurs in a prison setting. Prisoners and inmates have constitutional rights. They don't lose them. This would be a violation of the Eighth Amendment, and an inmate can use Section 1983 to allege that his or her constitutional rights have been violated as a result of this kind of conduct. So I've touched on this a little bit, but who can you sue using this statute? They fall into three main groups. So generally, it's somebody who acted, again, under color of state law. And this, again, falls into three different types of groups. The first group is people who work for the government. And this is fairly intuitive. Police officers, a sheriff, a sheriff's deputy, a correctional officer, a prison warden, an executive branch official, a state agency official, a mayor, a city official, or any other public official, someone who works for the government. Now, federal officials, they're state officials. That's who I'm covering. That's who I'm focusing on. Federal officials, they can be sued under this statute, but only if they're acting alongside a state or local official. This is known as a Bivens claim. I'm not going to cover it here because it takes a little bit of explanation and it's beyond the scope of what I want to cover and address here. But they can be sued, but only if they're acting in concert with a state or local official. Now, the second group of people you can sue under this statute is a private individual. Believe it or not, you can sue a private individual who conspires with a government official to violate your civil rights or your constitutional rights. And this can happen in many different ways. For example, if a police officer enlists the assistance of a private individual to help him or her spy on somebody or tap someone's phones or to search someone's home without a warrant, that private individual can be sued even though they don't work for the government. If they have acquiesced to the conduct and acted and assisted the public official in exacting that kind of harm, that individual, that private individual can be sued for a violation of Section 1983. And then finally, the third group, a municipality, a government entity can be sued under Section 1983, but it's a little bit different for municipalities. When suing a municipality, such as a town, a city, a county, a school board, or some other municipal government unit, you need to show that the municipality had a custom or policy that violates your civil rights. What does that mean? Well, it's a little bit difficult to show, but for example, say your local police department raids your home without a search warrant and searches and confiscates some of your property. If you're going to sue the department, and you can sue the officers who conducted the raid, that's fine. But if you want to sue the actual police department, you need to show that they have a custom or a policy of conducting illegal searches and seizures. So you're probably wondering, how do I do that? And that's going to be difficult to show. And it usually is. What you can do is use the public records law in your state. In Massachusetts, they have a public records law. In New Hampshire, they have a right to know law. Florida and other states, they have similar laws. Use those laws to request written documents concerning the raid or communications concerning the decision to conduct a search, and see if there's anything there that might reference an official position taken by the department as to how to conduct these types of raids. Maybe you'll find something that would support suing the police department, but usually you're limited to suing the officials because they essentially acted outside the scope of their duties and obligations and broke the law. So the third category of parties that you can sue a municipality, but there's an additional requirement here that you show that they have a customer policy that violated your rights. What damages can you recover? So I briefly covered this a little while ago, but let's delve into it a little bit more. So again, there are two types. There are monetary damages, otherwise known as compensatory damages, and prospective or injunctive relief. And that again is an order from the court that somebody stop doing something or that they do something. In this instance, it would be an order prohibiting somebody or some party or some public official from continuing to violate your rights. Punitive damages are sometimes available. This category of damages is well. Let me cover that in a second. But before I explain what punitive damages are, monetary damages usually include medical bills. So, for example, if you were arrested and the police used excessive force and you had to go to the hospital for a broken leg or a broken arm, your medical bills, the cost of those medical bills can be recovered as damages in a Section 1983 claim. If you, as a result of your injuries, you had to take time off of work, your lost wages can be recovered as damages. If you no longer can work in the job that you had and you had to go get a lower paying job, in other words, you've now suffered a reduced earning capacity or a reduced capacity to earn the wages that you were previously earning, you can recover that difference as damages. You can also recover damages for pain and suffering, including emotional distress, mental distress, depression. Obviously, you need to quantify those damages, and it would help if you had treatment records to demonstrate that you actually suffered those types of damages. You actually suffered that kind of pain or that kind of distress. Testifying yourself and relying solely on your own subjective perspective is usually difficult to use to support such an award of damages because it's one-sided. It's better to find or establish some record of treatment or have a therapist or somebody corroborate what you're alleging. A constitutional injury, the violation of your First Amendment rights, the violation of your Fourth Amendment rights, due process, those are quantifiable as damages. The actual injury to your constitutional rights itself. Uh, Juries, however, tend to be all over the place on how to quantify a constitutional injury, but that is something that you can recover money damages for. And then, of course, attorney's fees. In some instances, you can recover the cost of hiring an attorney to pursue this kind of a claim. Now, punitive damages are also available in some instances. Punitive damages are intended to punish the official who violated your rights. There's usually an additional requirement that you need to demonstrate in order to recover punitive damages. So, for instance, some of the cases that I've seen, if you have a correctional officer who used excessive force in restraining an inmate and they broke his arm or they broke his leg, if the correctional officers then go back and they usually have to prepare incident reports and describe what happened and then sign them. If they attempt to conceal what happened or embellish it in some way in order to conceal their own misconduct, that is considered conduct that would merit an award of punitive damages because you want to punish them. A court will want to punish them for that conduct and that action that they took to conceal what they did. That's an example of punitive damages and when they would be awarded. So there's sometimes available. It depends on the circumstances, and you usually have to show that they acted in bad faith to some extent. Now let's talk about one of the most common defense used by state actors and state officials or public officials when facing a Section 1983 claim. And this is known as immunity. There are two types of immunity: absolute immunity and qualified immunity. Absolute immunity, it means exactly what it says. Some officials cannot be sued for their official conduct, period. Okay? Judges, prosecutors, legislators, you can't sue someone for an official conduct that they took. You can only sue them if they engage in some kind of violation of your civil rights or your constitutional rights. In addition, the state itself, New Hampshire, Massachusetts, Florida, cannot be sued, period, without its consent. So you can't file a lawsuit in federal court against the state of Massachusetts. It's not going to work. It's going to get dismissed. There's a long line of case law on this. The state cannot be sued without its consent. You need to sue the individual officials. Now, when you sue them, but not in their official capacities, okay, you're suing them for the conduct that they committed, they can still assert what is called qualified immunity. And this is essentially, and I'm simplifying this to some extent, but there are some nuances here, but it's just a lot to get into. I'm not going to cover all of it right now. But qualified immunity essentially means that the official claims that he or she acted in good faith. They didn't mean to do what they did. They were acting in good faith. Now, there are two ways to get over this or to overcome this kind of challenge. One is you need to allege that they violated your rights. So this is what takes it outside of their official of their official capacity. Remember, I said you can't sue someone when in their official capacity. You need to sue them in their individual capacity, and it needs to be for the violation of some civil or constitutional right. So you need to identify the specific right that they violated. Okay. And then the second way to overcome it is you need to demonstrate that the right that they violated was clearly established. Those are the words used by the courts. Clearly established, such that the official should have known or would have known that their conduct was a civil rights violation. So, for example, I brought up the example of a correctional officer, a police officer who uses excessive force. Well, it is clearly established in the case law that when you have subdued a suspect, let's take the example of a police officer. When they have subdued a suspect and that suspect is now face down on the ground, the officer cannot then tase that individual in the back. Okay. That action is considered excessive force, and it's been established to be excessive force many, many times in many different courts. That right is known as a clearly established right. Okay. And an official in that situation, a law enforcement officer, should know that that would constitute a civil rights violation. So that is an instance when you can get around an officer's assertion of qualified immunity. Is there a statute of limitations on 1983 claims? There certainly is. What is a statute of limitations? Well, that is a time limit within which a lawsuit must be filed. It depends on the situation. For Section 1983 claims, the statute of limitations, or SOL, as many people reference it, it really depends on the violation being alleged. Most courts will treat these claims like personal injury claims. And for most personal injury claims, the statute of limitations is 3 years. So you have 3 years within which you would need to file a claim like this. 3 years from when? Well, the clock usually starts ticking when you discover that you have a cause of action. So let's take again the instance of a suspect being tased in the back by a police officer, or an inmate whose leg is broken by a correctional officer. The clock starts ticking at the time of the injury, to put it as simple as possible. That is when that individual discovers that they have a cause of action, because every all of the elements of the claim have accrued at that point. The conduct was committed, the injury was sustained, and that individual knows that they have damages at that point. So that is when the clock starts ticking for purposes of the statute of limitations. So you would have 3 years from that date to file the claim. And if you don't file it within that 3-year period, the claim lapses and you cannot pursue it. The only way you could pursue it, and again, this is a topic that's beyond the scope of this conversation. You can only pursue it under certain circumstances, but those usually will not apply here. Once the injury is sustained, once the conduct occurs, the clock starts ticking, so you have 3 years to file a claim. Now, how do you initiate a Section 1983 lawsuit? You start it like you would any other lawsuit. You do it by filing a complaint in the court that has jurisdiction. So if you were If this incident occurred in, in Massachusetts, for instance, you would file it in Massachusetts District Court or the Federal Court of Massachusetts. If it happened in Fort Lauderdale, Florida, you would file it in the federal court that covers that area. In that instance, it would be the Southern District of Florida. And you would file a complaint. A complaint is a document that contains several pieces of information. It identifies the court where you are filing it. And there are a lot of nuances here with this kind of document. I'm not going to explain in detail how to prepare a complaint. That's another topic for another day. But a complaint identifies the court that you're filing in. It identifies the parties, so the plaintiff and the defendants. The plaintiff is the individual who suffered the constitutional or civil rights violation. The defendants are the state officials or local officials or municipal officials that you are suing, who committed the conduct, who were engaged in the conduct that violated your rights. This document also has to identify the basis for jurisdiction. So why is it that this court has jurisdiction not only over the subject matter of the lawsuit, but the parties involved? And you also need to establish a basis for what's called venue. Why is this particular court in this particular location an appropriate venue for this lawsuit? The complaint also contains a section that recites the factual allegations that support your claim. This is nothing other than just telling the story. You explain what happened, you go through the events. I usually like to provide as much detail as possible in a complaint because it will help you overcome a motion to dismiss if any of the defendants chooses to file one. And that's, again, a topic for another day, but provide as much detail as possible in your complaint about what happened, who was involved, include dates, times, names of individuals, identify precisely what happened, and then explain how you were impacted by those events. Then the next section lists the counts or your claims. So if the police, for example, raided your home without a warrant, you would include a claim for violation of your Fourth Amendment rights. If you're an inmate and the police, the correctional officers tackled you and beat you up and you sustained injuries, that's a violation of your Eighth Amendment rights. So you need to list each claim and you need to set forth the elements of each of those claims. Okay. And that goes in the section that follows the factual allegations. At times, you would incorporate some of the facts into the recitation of your legal claims so that you can match the facts to the specific elements of each claims. But you need to include a section that identifies the counts or the claims that you're pursuing against these officials. And then at the end, you include what's called a prayer for relief, which is a request that the court rule in your favor and award you damages. You can identify what types of damages you're seeking. They can be compensatory damages or money damages. You could identify or request an injunction. So if you're an inmate and you want the correctional officers to be prohibited from treating you in that way again, you can request that the court issue an injunction prohibiting them from ever using excessive force with you ever again. If you're a civilian who's been excluded from a government building, you can request an injunction from the court directing the municipality to allow you access to that building or that space. And then at the end of the document, you sign it. You sign your name, and you're bound by the information in that document. So it needs to be true. When you sign a document and you file it in court, you're under an obligation to tell the truth. And that's what a complaint includes. Those are the sections, and that is the information that you need to include in a complaint to file a Section 1983 lawsuit. And that's essentially it. That's how you do it. So again, Section 1983, it's a statute. It's a procedural mechanism that allows you to vindicate the violation of your civil rights or your constitutional rights or some other right protected by a federal statute. You can sue any number of state or local officials. You can recover money damages or pursue injunctive relief, and the conduct that you can challenge includes a whole array of different uh, types of actions, ranging from police misconduct to some violation of a policy or some illegal act undertaken by a public official. And you would pursue it by filing a complaint in court and proceeding with a lawsuit, just like any other instance in which you sue somebody in court for damages or for injunctive relief. Thank you for listening. um, I get these inquiries all the time, and I'm happy to provide an explanation and outline the different components so that people can then use this information for their own benefit and for their own interest. This is, again, not legal advice. If you have any questions, you should obviously consult an attorney, and because there are a lot of nuances that are attached to many of the topics that I've covered here. So thank you for listening to the Law of Fojo podcast. Make sure to join our Facebook group if you haven't already. We also have, we're also on Twitter, Facebook, and Instagram. Law of Fojo is our handle. Thank you for listening, and be sure to stay tuned next time as we continue to cover different topics, both political and legal topics as they come up. And thank you, and we will see you next time.